Hi, I'm firearms attorney Gilbert Ambler, and I'm back today to talk about one of the things that we living here in Virginia have to look forwards to in 2026. And I say that sarcastically, as you might imagine, under the new Democrat controlled regime and all of the gun laws that they're likely to pass. And that is permit to purchase requirements. And I'm not making this video just to tell you, hey, this is probably coming and you should run out and buy guns right now if you want to get them before someone like Virginia's new top cop, Jay Jones, Jay Texting Jones, has access to your permit purchaser information. Instead, I'm making this video so that we can talk about where else has permit to purchase laws, why have there been challenges to those laws that really have been shot down and not gone anywhere, and how might we challenge such a restriction if it does come to pass here in Virginia. But before we dive into this content, as always, if you have not yet hit that subscribe button, what are you waiting for? Hit subscribe, like, comment with your thoughts, and share with your friends. That way you and your friends can both keep getting this important Second Amendment related content, especially as it relates in Virginia heading into 2026. And before we go any further, if you have not yet marked your calendars for Lobby Day, mark your calendars, plan to show up in Richmond for Lobby Day. If you were there in 2020, you remember how cold it was, but how powerful it was and what an impact it made on the legislature that could have passed back in 2020. Now, can we repeat that success in 2026? I don't know, but it will sure help if people show up. Again, Martin Luther King Day in Richmond, Virginia. You don't have to be from Virginia to attend. Be there. I hope to see you all there. But let's move on to what we're actually talking about today, which is the permit to purchase laws that have been starting to be bandied around. This is not something we had previously seen seriously proposed in Virginia. It is something that appears is going to be seriously proposed and pushed in 2026. What does it generally look like? It generally means you've got to go potentially take classes, pass a background check, potentially even get fingerprinted and get yourself a little card that identifies yourself as a eligible firearms purchaser. Does that mean you don't have to do any future background checks? Probably not, at least not the way these permit to purchase laws have worked elsewhere. It just means that the government gets to build a handy dandy list of everybody out there that wants to buy guns. And that's why I say potentially you might think about stocking up right now on anything you anticipate having desire for prior to such laws going into effect. But this is not a new idea. There's several other jurisdictions that have these laws, and really most of the jurisdictions that have such restrictions have not even seen constitutional challenges to it. And we'll talk about what some of these jurisdictions are. We'll also point out that probably the reason you're not seeing a lot of constitutional challenges is, for the most part, the jurisdictions that have passed these restrictions exist in anti-gun places. It's not like you see Texas and Louisiana on the list of states with permit to purchase laws. Instead, you're going to see the traditional list. Let's run through it. California, Connecticut, the District of Columbia, Delaware, which is pretty recent, Hawaii, Illinois, Maryland, Massachusetts, Michigan, Minnesota, which again, once we get up into that 8th Circuit, those are some of the ones that are a bit more unusual. Nevada, New Jersey, New York, Oregon, Rhode Island, and Washington apparently has one set to come. And so that's something that's set to go into effect in the future. Now, there was a very recent challenge in Delaware, and I read through that challenge where a preliminary injunction was denied. And what Delaware put into place was a permit to purchase for handguns only. And the challenge, which was brought in part on behalf of the NRA, appears to mainly focus not so much on the Second Amendment, but to predominantly focus on whether the restrictions and whether the permit to purchase would really delay people from acquiring handguns unnecessarily in the first place, whether what Delaware was saying the process was, whether that process was even feasible. And so the challenge focused on Delaware's Administrative Procedures Act, and the decision focused on the plaintiff's claims that the Delaware State Police were not going to be able to provide the permits as they said they would provide them in the time frames and on demand as Delaware said it could happen. And unfortunately for the plaintiffs, the Delaware State Police essentially showed up with receipts and had evidence that they were in fact issuing permits as they said they would issue permits. Now, I didn't go past the decision itself, so I don't know whether the plaintiffs in that case have some strong arguments that the court just didn't talk about. But because the decision did not really focus on the Second Amendment, there wasn't a big appealable issue on the basis of the Second Amendment there. Now, that case can continue on. That's at the preliminary injunction stage. So it can certainly continue on still, and they could reach the merits, and it could still be overturned on the merits, but at least no preliminary injunction was granted. The other one that directly is going to affect us here in Virginia is Maryland, because Maryland has a permit to purchase, that handgun qualification license, the HQL. And this was challenged in Maryland Show Issue versus Moore. I think this was a 2024 decision, so post-Brune. And what did the Fourth Circuit do? The Fourth Circuit did Fourth Circuit stuff. They seized on negative dicta from the Brune decision. What was the negative dicta? Well, footnote 9 of Brune talks about the presumed constitutionality of shell issue licensing. And they said, look, since this is shell issue licensing, you just have to meet the qualifications and you can get your handgun qualification license. It's presumed to be constitutional. We don't even have to apply a text, history, and tradition test because Brune already said we presume this is okay. So what are the lessons here? Number one, the dicta is very unhelpful. We talked about this in some other videos. Dicta from the Supreme Court saying we presume certain things is not helpful because even though the Supreme Court tries to make clear that even when we presume things, there's still a time and place to challenge it, what we find is when those challenges occur, they don't go far because the lower courts say, see, the Supreme Court already presumed this. So the dicta is unhelpful. The second thing that I think is really important out of this decision is that for all intents and purposes, they have undone the word infringed. They've taken the word shall not be, or the term shall not be infringed, and they've taken that infringement idea and said, well, we can have all sorts of infringements because infringements really in this context only means a prohibition. We're only going to consider an infringement if it prevents you from exercising your right. So since you can still acquire these firearms, you just have to jump through a bunch of additional hoops. We don't consider that an infringement unless it rises to the level that it absolutely prevents you. And of course, that is reasoning that, in my opinion, undoes the entire meaning of the amendment and largely would undo the meaning of any constitutional amendment, right? Can you imagine if instead of saying Congress shall make no laws affecting religion, if instead of the shall not issue no, instead, or the establishment clause that we're talking about here, if they said, yeah, Congress can make all sorts of laws establishing as long as they don't ultimately make you swear to be that religion, right? Congress could pass a law saying you have to go to Catholic Church as long as they don't swear that you have to become Catholic. Would that become constitutional? I don't think so, right? You would think wildly unconstitutional. And yet that's pretty much how they're treating the Second Amendment. Finally, what would a possible path forwards be to challenge this in Virginia? Well, there's two ways. One would be a federal challenge, right? You can run the federal challenge back up through the Fourth Circuit. It's probably going to be foreclosed based on the Maryland case, but you can hope for a Supreme Court review. I think that's a rough road to hoe, if that makes sense. The other way you could challenge this is under Virginia's independent constitution, which predates the United States Constitution. Virginia's Constitution had its first mention of the right to arms in 1776, which of course was before the United States 1791 Bill of Rights, and we could focus on that Virginia Constitution and run a Virginia constitutional challenge through state court. What am I telling you about this? Well, there's some bad things that are going to happen when it comes to Virginia gun law. Do what you can right now. Show up to places like Lobby Day, make your voices heard, and get ready, buckle up for the legal challenges that are sure to come. If you enjoyed this content, go ahead, hit that subscribe button. Until next time.